All right. We have already formed a quorum and we have passed the scheduled time, so it's been hard to form a quorum. So let's invite the administration team to join us.
政府當局咧提供咗2021。
The administration has already submitted responses to issues raised at different meetings this year. So we have got papers number CB bracket 1824 bracket 01206. So can the administration walk us through the two responses from the administration, please? So we've got 3 meetings being held in tandem in this building. That's why members have to shuttle between different rooms. Good morning, Chairman. Good morning, members. First of all, I'd like to refer to paper number CP bracket 1824 bracket 04. That's the administration's response to issues raised at the meetings held on the 10th and the 14th of April 2015. So it's about the conduct of the intermediaries, and we do have a provision very set out in detail as to the requirement for the intermediaries to act in the best interest of insurance policy holders, and we are now discussing how we can come up with a response. So we'll be responding to that later. And second is about the IAT, the Insurance Appeals Tribunal, and there are some comments saying that we should make reference to section 260 bracket 2 of the SFO concerning the costs awarded by the MMT, the Market Misconduct Tribunal. In other words, if the IAT were to award costs to certain witnesses for coming to give evidence, then the administration should shoulder the costs for that. But then under the IAT, we do not have a similar provision. We do not think that we should compare that with the MMT under the SFO. On the contrary, we believe that we should compare that to other similar appellate mechanisms. For example, the Securities and Futures Appeal Tribunal, and also other tribunals, because they are all there to review the decisions by the executive. So in awarding costs, the IAT will have to require either party to pay, but then under the MMT, it is not there to review the decision made by the SFC, but then if the SFC is of the view that misconduct has taken place in the market, then the MMT will be asked to make a decision. So the roles and functions are very different. So we believe that it's not appropriate to make reference to the relevant provision under the SFO concerning MMT, that is section 260 bracket 2 of the SFO. As regards the appointment of members and proceedings of IAT, last time it was mentioned that in the course of the review, if chairman or ordinary members of the IAT resign or are unable to discharge their duties, then it says that we would like to say that in case there is a change in a person who is acting as a chairperson or a member of the IAT when a review is in progress, the hearing may continue if there is consent from both parties to the review, and the hearing should begin anew in the absence of such consent. So we will be moving a committee stage amendment to clearly stipulate the above arrangement. So we believe that that's the appropriate arrangement. And last time we also discuss whether the IAT can determine a case behind closed doors, but then we believe that concerning the review procedures, they should be open, but then we just want to have a flexibility so that if the IAT thinks that in the interest of justice, it needs to hold a sitting in private, it will be okay as to how we have made reference to other experiences or similar setups, so that if there is procedural justice requirements, or if it would be impartial and just to both sides involved, then the IAT might decide to hold a sitting in private.
Regarding the tribunal operations, we have included these in Annex 10, and we want to repeat that to Annex 10. We need to submit CSAs before they can be amended. It cannot be amended by negative vetting. Separately, in the meeting, we also mentioned the English term insurer, whether the Chinese could be converted into 保险公司. We feel that that is appropriate because it would make the legislation clear. But if we do so, then Clause 41, it's rather long. If we were to make that amendment, then a lot of effort would be expended in review. So we hope that this scrutiny work, we won't make the amendment, but we would have it on record when the insurance company ordinance is amended. We will make it in the future occasion. We agree with the intention, but we propose that it be done on the next occasion because a lot of work is involved. Some members also suggested that there were some accounting terms involved, and one opinion was that whether we need to consult the Accountants Association to see whether there is any difference in drafting terms between the accounting and insurance perspective. Regarding the accounting terminology, we don't have Chinese terms, so there is no amendment needed because of that. Chairman, so should I continue? So do we have any follow-up questions on document 04? Otherwise, we'll continue to document 05. Thank you for the response. I think I mentioned the question about the English term insure. Well, it's not urgent. I can accept your proposal. But as you said, if we were to amend that in the future, we have to do so very thoroughly, because insurer, it's clear now, but a long time ago, the term insurer connoted something different. Well, it's strange. Our legislation, the terms, for example, authority could either represent a person or an institution. So if your intention is that insurer is going to refer to a company, then of course in the future we need to do so very thoroughly. Okay, next document is document 05. The paper 05 responds to some discussions held on the 20th of April. Well, the first question deals with offenses that are related to misleading descriptions. The Commodities Ordinance, the Commodities and Dutiable Goods Ordinance is not applicable to the Insurance Company Ordinance. As I said, the Commodities and Dutiable Ordinance deals with financial products. Now, we have listed our legislation in the annex. So, in short, the Commodities and Dutiable Goods Ordinance is not applicable to the Insurance Company's Ordinance. So, if a person intends to use dishonest means, then according to the Insurance Company Ordinance, the insurance authority is the law enforcement agency to deal with that. The next issue is related to restriction on the use of certain terms and representations associated with insurance business. Put simply, we want to safeguard the public, that is, registered companies and registered individuals are the only people that can provide intermediary services. We had made reference to Singapore, New Zealand, Australia, and so on. And regarding insurance, they have similar restrictions. Now, regarding body corporate and partners, when a registered company has breached the law, there was an opinion that in the controlling persons, they are regulated by this ordinance. So if the company breaches some laws, then are they also responsible? So senior management and controllers, the measures are very severe. So regarding the responsible persons and the controllers, we require them to be fit and proper. So if they do not comply, or if they do not reach the standard, it's not a criminal offense. So when the related institution has breached law and we have facts and evidence, if it were because of the controller's instructions or then they cannot be held unaccountable. So if there is evidence that the controller has condoned these actions, then they need to bear criminal responsibility. In recent endorsed ordinances, for example, in MPF and the money laundering ordinance, we have similar legislation. On the last occasion, we also mentioned that the insurance authority, they can undertake prosecution work, and some members felt that at the current state, we should not allow people without professional qualifications to undertake this work, and we agree. Now, of course, our original intention was that the insurance authority would allow its in-house lawyers to do this work. We accept members' suggestion that we should delete the new section 124(3). That is, the insurance authority cannot allow staff without professional legal qualifications to undertake prosecution work. Now, lastly, the status of the IIA's codes and guidelines in court proceedings. Put simply, information that has evidential value. For example, when there is a court case, the judge should be able to see whether the affected person has complied with the guidance issued by the IIA. In this legislation, there is no effect. There will be the burden of proof will not rest with the defendant. We just want to clarify this. And we also have a drafting issue on where the phrase counsel or solicitor appears in the law, in the legislation. Now, we have chosen the term counsel to represent barristers. In the term barrister was used in section 124(3). Why do we use this term? It's because we are referring back to the legal practitioner ordinance of definition of barrister. Now, but in paragraph 10 of this document, we had said that we would delete. We had said that we would not allow the IIA to use people without legal qualifications to conduct prosecution. So this matter is not, therefore this issue does not become urgent. Now we welcome questions. So do members have any questions regarding document 05? Mr. Chan Ginbo. I'd like to ask a question about offenses by body corporate and partners. Now, the controller, the partner, they have taken part in a crime, then nobody would side with them. But now, the way it is drafted now, then the innocent might be involved. You say, when you say condone or neglect, neglect is very clear. But what do you mean by the other terms? So at this stage, I want to reserve my right to. I just want to highlight that there is a problem, and we would wait for our industry to seek a legal opinion before we follow up on this issue. So, okay, we've heard your view. The member has reserved his right to follow up on this issue. He awaits legal opinion, and there might be a new decision later on. So, if the government does not accept Mr. Chan's views, will Mr. Chan follow up? Well, we would like to settle the matter peacefully. We would like to negotiate. Any other questions? Mr. Leongakit. Chairman, could you allow me to return back to document 04? I've just digested the content regarding the costs awarded by the tribunal. Now, the document simply states that costs and awarded by the Market Misconduct Tribunal. We will make comparisons to the Securities and Futures Ordinance and Market Misconduct Tribunal, and the document says that they feel that this comparison is not appropriate. But in paragraph 4, have they highlighted a difference? But in fact, there is no a difference. The Market Misconduct Tribunal it is a hearing procedure, adversarial procedure. So whether it is a statutory body, why is, if the MMT is not challenging the institution's decision, and I just want to clarify that. I don't quite understand the difference. How can that be the basis for handling legal costs? Do you have any response? Allow me to explain. The IAT, we feel it's similar to other tribunals, for example, the Securities and Futures Appeal Tribunal or the Anti-Laundering Tribunal. It is at the appeal level, but the Market Misconduct Tribunal, even though it's called a tribunal, but in fact it is at the first level. It's the first layer of a tribunal. So the two are not the same, even though they're called tribunal. Even though you say, as Mr. Leung says, it's an adversarial setting. But the regulatory authority, they have made a ruling regarding the activities, and the affected party has made an appeal. So it is now being decided at the second tier. So it is more appropriate to make a comparison with financial services appeals. So the IAT handles the first level, and if there's a dissatisfaction with the tribunal, then an appeal will be held. So you're saying that the first occasion where the case was handled, and now this is so after the so-called first hearing is heard, we now into the second hearing. So you're saying that first hearing should be compared to first hearing and second hearing to compared with second hearing. Any other questions? Then we enter the second agenda item, clause by clause scrutiny. The legal advisor in 2015, 5th of May, regarding the drafting issues had written to the government, and the document related is A241415-06. The government will provide a written response later, and members, when they conduct a clause-by-clause scrutiny, the legal advisor will highlight her concern, and the government can provide a verbal response. So today's scrutiny should start from Clause 84 regarding the amendments, the Insurance Companies Amendment Bill 2014. We should start with the Chinese section 1833-1314-01, page 322.
And the administration has already provided a paper, which is an index to the bill, paper number CP bracket 1369/14-15 bracket 03, which sets out the policy issues and the related papers involved in individual provisions in order to facilitate members' scrutiny of the bill. So we may now start. So we'll start from clause 131 from page 322. Well, we briefly talked about 133 last time, and that's to authorize the IIA to gazette certain codes and so on. So that's to provide some guidelines for the trade to follow. And as we explained in our earlier response last time, bracket 4 provides that a failure on the part of a person to comply with the provisions set out in a code or guideline does not in itself render the person liable to any judicial or other proceedings. However, such codes or practices or guidelines can be accepted as evidence. And also for codes and guidelines that are published in this clause would not form part of the bill. And then on page 323, that's clause 132, it says that the Chief Executive and Council may by order publish in the Gazette certain levies. And the specified levy can be in the form of a percentage of the premium payable for the contract of insurance as a fixed amount, and so on and so forth. So with regard to the levy to be specified, if there is any failure to pay, the authority can recover it as a civil debt. Chairman, can I say a few words on the background to this? Yes, please. Speaker is not coming through. Well, we are referring to the levies under the contract or under the insurance policy, so that can be set as a percentage of the premium. So that can be set as a percentage of the premium. And in the event that the authority has accumulated the fund to a certain level, then we do have a mechanism to lower the levy. That would also be mentioned in 133, so that's the background to the levy. So I'd just like to bring it up for members' information. All right, Mr. Chen Kin Paul, thank you. So for policyholders, you're talking about the protection fund and also the IIA levy. But then within the industry right now, we have a motor vehicle insurance. So a certain percentage will be charged for various services or purposes. So altogether, we are already paying some 10%. So will you be adopting the old approach, or are you focusing on the insurance policy protection fund or whatever? Well, in simple terms, Chairman, the answer is in the affirmative. Okay, no further questions, then please move on. Page 324, clause 133, as Mr. Zhang just said, 133 is to empower the CE in Council to lower the levy. And it provides that, well, if during a financial year of the authority, the requirements set out in subsection 2 are met, the authority must consult the Financial Secretary with a view to recommending to the Chief Executive and Council that the rate be reduced. So, if the reserves of the authority are such that it would be more than twice its estimated operating expenses and so on. So, next is 134. 134 says that if the Financial Secretary proposes to publish a notice under section 13AE bracket 14 or 121 bracket 5, the Financial Secretary must publish a draft of the proposed notice. So it's about the exemptions for intermediaries to obtain a license. So given the two circumstances, if the FS were to publish a draft of the proposed notice, then it would have to be in line with the procedure set out in clause 134. It says that the FS will have to publish the draft and invite the public to make representations, and it would also have to publish a report setting out the representations that he has received on the draft and his response, and he will also have to set out the differential views that have been expressed. Please move on. Next, 135 on page 326. So it provides that the authority may specify forms, and these forms include forms for application or representations and so on. And these forms can require the applicant to make certain statutory declaration. And then on page 327, clause 136. 136 bracket 1 says that the CEIC may by notice published in the Gazette amend Schedule 9, and Schedule 9 provides that certain specified decisions made by the IIA, and the interested parties may appeal against that. And it also provides that with approval from the FS, the authority may by notice amend Schedule 1 to 8. And then bracket 3 says that the Legislative Council may by resolution amend Schedule 1D. We'll be talking about 1D later. So that's about certain duties and functions that cannot be transferred by the IIA. So can you tell us more about that? Schedule 1 to 8, what are they all about? Well, earlier on, under the old ordinance, for example, on insurance, on types of insurance business, and also for insurers, certain accounts that they will have to report to the IIA, and also certain applications that they submit to the IIA, what information would be required. So relatively speaking, they are executive or administrative in nature. Yes, Mr. Sin Chung Kai. I was a bit slow, Chairman. I'd like to go back to 133. All right. Clause 133, bracket 2. I don't quite understand it. 133, bracket 2. We are already on 133, okay? So it's a lot earlier. No, just a few pages earlier. Page 324, clause 133, on reduction of levies, all right? So it's about reduction of levies. And if the requirement is right. All right, I can understand A. That is, if the reserve is already twice that it is estimated, and number 2, that the authority has no outstanding debt. What does that mean? So what kind of debt will the authority have? So that's on page 324 of the English version, 133 bracket 2b. Chairman, actually, this provision provides for some flexibility. So in making recommendation to reduce the levy, of course, we will have to look at the financial position of the authority. And earlier on, we talked about the reserve, and of course, that will have to be netted against certain debts. And Chairman, you asked what kind of debt will the authority have? Well, it's hard for me to say now, but then as an operating institute, just by way of an example, if indeed it procures certain things and has to repay by installments, then these would be treated as outstanding debts because there are outstanding payments. Whether or not it might procure an office accommodation. Well, that's not my question. I'm not asking what kind of debts will the authority have, but then under subsection A, you said that the reserves of the authority, after deducting depreciations and all provisions, are more than twice its estimated operating expenses for the financial year, and B, that the authority has no outstanding debt. In other words, what if it has? Because you have not said that that would be netted against the outstanding debt. In other words, if there is any debt, then you will not reduce the levy. All right. So if they just take out a very small loan and then they do not repay it, and then you will not be able to reduce the levies. Is that right? So is it that so long as they have a small debt, then they will not be required to lower the levy? All right, I'll just go to the bank and take out a $2 million loan, and then even if the reserves is 3 times that, I will still not reduce the levies. So my reserves is twice what I would need, but then I can just take out a small loan, and then I will not be required to lower the levies. All right, these are these are the tricks that they can play. Because if the purpose is to net it, then why don't you put it here? So I think if you can put it in clearer terms, that would be better. All right, thank you for your comment. The purpose is that after the netting, the reserves would be more than enough for it to run for at least 2 years. Then they will have to lower the levy. All right, we'll go back to see if we can improve it. I understand the point made by Mr. Sin. Okay, Mr. Sin, are you happy with the response? Yes. But Chairman, well, I think they are responding to the industry's comments because the SFC, I mean the SFO does not have a similar provision. In fact, I have not asked that question yet. So I think the TIC too, the TIC, the Travel Industry Council, also has a similar provision. They also have a levy. So the stamp duty for the travel industry. But then in the future, does the authority have to submit its budget to this council? Chairman, we already discussed that last time. We also provided a written paper, so we would make reference to the practice of the SFC. In other words, the budget would be submitted to the FA panel for discussion. Okay, point taken. That's all right. Because you specifically refer to lowering the levies, but what about increasing it? Has that been mentioned? It has been mentioned under 132. 132. Chairman, in fact 132 says that if you want to increase the levy, then under 132 you will have to amend the regulation. That is the percentage of the levy, because the percentage of the levy has been provided for and gazetted. All right, Alan Lau. 132 bracket 1 apparently foresees this situation whereby the CEIC will, by order published in the Gazette, specify a certain levy, and the order will also specify that the specified person will have to pay this levy in the order for every contract of insurance.
呢個指明的人
I'd like to ask who the specified person is. And of course, you won't publish a gazette for every insurance company and every contract. So can you tell us what the contents of the gazette will be? Could you tell us what you have in mind? Chairman, the drafting is to provide some flexibility for the future. In our previous document, we have already explained, the Secretary had also explained, that is, in the future, when all contracts, all insurance contracts, excluding the exempted ones, excluding the reinsuring contracts, they will have a levy, and when we refer to the specified levy, we're referring to this levy, and the specified person is the person insured. Then they will have to pay a levy, but our drafting allows some flexibility depending on the future, whether some contracts have to be higher or lower. It's just a flexibility. But our calculations and intention is to include all contracts. They will be subject to levy. But we have two types of insurance. We have a life insurance and non-life insurance where there's a maximum. So the two maximums are different. And if you look at the instruction to Gazette, they have the detailed instructions. Well, Chairman, sometimes when you have too much flexibility, then it creates some concern amongst legislators. The problem is the specified person is not defined in this draft bill. So if you say there is a certain levy and you have not made it clear how it is to be classified, will there be a schedule, a table in the Gazette? Certain types of contracts will be subject to a certain percentage of levy. For example, when you say specified person, aside from the person holding the contract, well, who else can be a specified person? Because this material will not go through the legislature again. Will you return to the legislature? These Gazette instructions are subsidiary legislation. So whenever there is an amendment or when it is endorsed first, it will return to the Legislative Council for positive vetting. So I understand what you mean by, I understand your question of what you mean by specified person. In our consultation, we made it very clear. It refers to the person holding the contract, the person purchasing the insurance. They will be subject to a levy according to the premium, and the contract will spell out very clearly the levy. Why do we further clarify the level of levy and so on? Is because we have some life insurance contracts. The maximum levy is only $100. So that will be spelled out very clearly. If it's a life insurance contract, the maximum is $100. So it makes it convenient and it allows flexibility For example, reinsuring contracts will be exempt. So reinsurance is exempted, and we will spell out the maximum and which contract holder will have to pay what sort of levy for what insurance product. So if there are amendments and if we need to publish in the Gazette, we will have to come back to the Legislative Council. Well, at least we can rest assured there will be a positive vetting. But I still don't understand, aside from the contract holder, who else is the specified person? Why can't you just spell it out? You just say one for a particular contract. We can have very complex situations. But there's only one type of specified person. What else do you foresee? Well, I think that's just a drafting issue. As I said just now, we have in mind certain people who purchase certain insurance products and hold certain contracts. But if you want to clarify the drafting issue, you'd have to follow up with a DOJ draftsman. So we have different contracts and different contract holders. That's why they have different levels of levy. My understanding is there is flexibility, but this flexibility creates some worry. Well, your flexibility, you just need to allow flexibility for different types of insurance products. But this flexibility should not extend to the people holding the contract, because there's only one type of person holding the contract. Well, you need to look into this with the legal draftsman, and could you provide a written response on the next occasion? Let's continue. Moving on to clause 137 on page 328. We will move on to Schedule 11 later. Schedule 11 will deal with transitional arrangements. Moving on to page 329, Schedule 1, we have the classes of insurance business. We have only provided some amendment of the wording. We have amendments of the term insurance authority. Moving on to page 331, we have Schedule 1A. We have regulated activity, material decision, and regulated advice. The purpose, as we said previously, for regulated activities, they need to have a license. So we have regulated activity that would include the act of negotiating or arranging a contract, the act of inviting or inducing or attempting to invite or induce a person to enter into a contract of insurance, the act of inviting or inducing or attempting to invite or induce a person to make a material decision, and or the act of giving regulated advice. And we also have regulated advice, that is in Part 3. Part 2 deals with material decision. Material decision A is the making of an application or proposal for a contract of insurance. B is the issuance, continuance, or renewal of a contract of insurance. C, cancellation, termination, surrender, or assignment of contract. D, the exercise of a right under a contract of insurance. E, the change in any term or condition of a contract. F, the making or settlement of an insurance claim. Regulated advice is the making of an application or proposal for a contract of insurance, the issuance, continuance, renewal of a contract of insurance, the cancellation, termination, surrender, or assignment of a contract of insurance, the exercise of a right under a contract of insurance, the change in term and condition, and the making or settlement of an insurance claim. Any questions? Mr. Sin Jong-gat. Well, I dare not challenge your expertise, but I'm not very comfortable with the wording. When you invite a person to make a contract, but inducing the Chinese, could you make it more neutral? I wanted to look up the English wording, but the Chinese Yao Si, it sounds like someone is tempting someone. Can it be more neutral? Well, it doesn't have to be positive, but can it be neutral? Thank you, Chairman. Thank you, Mr. Sin. Mr. Sin is referring to the English term induce. Induce has the connotation of using a material fact or action to have someone do something. So the related Chinese term yao achieves that purpose. So in Chinese, we combine the terms yao wa, and that gives it a negative connotation. But the Chinese term yao is exactly the English induce. You're trying to persuade somebody to make a decision. I'm not a Chinese expert, but it sounds negative. Chairman, allow me to follow up. Under the self-regulatory framework, registered intermediaries should not induce people. They use similar wording. When you induce someone to change insurance, that sounds immoral within the industry. We need to ask Mr. Chan Ginbo. But if you start with inducing, you're just asking people to purchase a new insurance contract. You're not persuading them to change a contract. Mr. Xin, this is just for your consideration because I'm referring to a dictionary here. Induce includes persuading, manipulating. This is just a handheld dictionary translation. Well, the Chinese chokxi doesn't sound so negative, so I'm not sure if that is relatively better. The industry refers to yao dou, and in my dictionary it says chokxi. Could that be more neutral? There is the Chinese yao si. There is that we have this translation version. We can consider that. If you use the Chinese chokxi, the English equivalent might be urge. As our legal draftsman said, we were saying just now that when you induce, you might use gifts or other forms of incentive to sign a contract. Whereas chokxi is urge under certain circumstances. They are made to sign a contract in a very rushed manner. There might be some difference. We'll look into this and respond on the next occasion. Mr. Sin, is that a strong request? I understand what you're trying to regulate, and even though it sounds like I'm very stringent in regulating these activities, but I think we should have more neutral wording, because the Chinese yaowak sounds negative. You can look into this. Well, the DOJ draftsman can look into this and see other legislation whether they use similar wording. If so, it is not appropriate for us to insist on amendment. Mr. Chan Ginbo. Chairman, I think I'd like to ask, because I always get the questions, which company is better, which product is better. Could I suggest a company? Do I need a license? A lot of participants, they make referrals, but when you refer to inviting or inducing or providing advice, regulated advice, I'd like to clarify. Could you resolve any undue concern?
Here we are referring to, well, in the course of his business or employment for a consideration or reward, he does that. So if you're just making referrals to your friends instead of in the course of engaging in your business or employment, you're making the referral, then that would not be a regulated activity. So the relevant provisions are on the 64G. So you mean there you will set out the details, so should we rely on that provision because unregulated advice or regulated activities and so on? Well, 64G are the prerequisite, which sets out the situation in which you're in, and if you do what is set out in A, then the two will be combined, because under 1A it talks about 64G and 64 set G. So you will have to look at 64G so that in his business and employment, if he is doing this for a reward, and if other people ask you, but then you are not doing that for the purpose of your business or because of your employment, or you are not doing that for a reward, if it's just a friendly advice, then you will not be caught by 64G. In other words, 64G will set out the conditions under which that would be defined as a regulated activity. All right. Page 333 or page 332, Schedule 1B, is about the constitution and proceedings of authority, etc. In fact, earlier on, we also explained that the authority will then have a chairman, a chief executive officer, and no less than 6 directors. So under Schedule 1B1 says that the C in Council may appoint an executive director or non-executive director of the authority. So if the executive director is vacant, then it can be filled by the deputy chairman, and one director can also act as the chairperson of the authority. Bracket 5 says that the financial secretary may designate an executive director or non-executive director of the authority to act as chairperson of the authority for any period during which the chairperson of the authority is unable to act as chairperson due to illness, absence from Hong Kong, or any other reasons. And it says that if the position of the executive director becomes vacant, then another person can be appointed to act in his place, and the CE will decide on the membership, and the members of the authority can also give written notice to the chief executive for resignation, and the authority would also have to pay any remuneration as designated by the chief executive to its chairperson and members. And if it's satisfied that a particular member has already become a public officer or has gone bankrupt or is mentally incapable, so that he is not able to discharge his duties, and also B says that is convicted in Hong Kong of an offence that is punishable by imprisonment for 12 months or more, or is convicted elsewhere than in Hong Kong of an offence, but that if committed in Hong Kong would be an offence so punishable, or is otherwise unable or unfit to perform the functions of a member of the authority, then the chief executive may declare the member's office to be vacant, and the chief executive must give notice of the declaration in a manner that the Chief Executive thinks fit, and the decision would also have to be gazetted. Mr. Sin Chung Kai, I suspect that you've just copied those from other pieces of legislation. But then under B, I don't think the public will find it acceptable. All right, if there is a director who has been sentenced to 3 months jail, all right, well, even if it's not 10 months, well, still you will have to be dismissed. Yes, if you are sentenced to less than 12 months, let's say 6 or 7 months, then I don't think the public will accept that he be kept as a director of the authority. Of course. So what about the perception of the public? Should any member of the authority be convicted and then imprisoned? So given, well, for similar structures or setups, would the 12-month threshold also be adopted? Chairman, we have made reference to some existing legislation before coming up with these provisions. We have made reference to the SFO and also the Financial Reporting Council's ordinance. What about MFAs? That is MPFA, or the Monetary Authority, or the HKAA, and even the HA, Hospital Authority. Do they have similar provisions saying that if a member has been sentenced to 12 months jail, then he'll be disqualified or dismissed? Chairman? It's not that he has been sentenced to 12 months jail, so it's just an offense punishable by 12 months imprisonment. So even if it's just sentenced to three months jail, he can also be dismissed. Well, for LegCo members, if he's sentenced to 3 months jail or more, then he'll be disqualified. So it's an offense punishable by 12 months imprisonment. So he may not necessarily have to be sentenced to 12 months. So long as he's sentenced under a particular provision or under a particular offense punishable for 12 months imprisonment, then he can be dismissed. Yes? So there are two possibilities. Yes, Mr. Sin? You brought up this issue. So it's not that he has been sentenced to 12 months jail. So it's an offense punishable for 12 months imprisonment. But then if it's a suspended sentence, or if the sentence can range from 1 to 12 months, the Chief Executive will still be able to remove him, so to speak. So apparently it's even more stringent than the LegCo situation. Well, it's okay. So here you're referring to an offense which is punishable by imprisonment for 12 months or more. All right? That understood. So this problem has been resolved. Yes? Please move on. So subsection 5, disclosure of pecuniary interest by members of the authority. And 1 says that if a member of the authority has a pecuniary interest in a matter that is considered or is to be considered at a meeting of the authority, and if that might cause a conflict with his work, then the member must, as soon as practicable, after becoming aware of the relevant facts, disclose the nature of the interest at a meeting of the authority, and then the authority will have to record that declaration in a record for public inspection. And then for that particular member, after he has made the declaration, he will no longer be allowed to be present during a deliberation of the authority with respect to the matter under subsection 4, or take part in a decision of the authority with respect to that matter. Mr. Sin? That is very clear. So it's about pecuniary interest. But then very often in English, we talk about conflict of interest, not just pecuniary. So it might not just include pecuniary interest. It would involve all interests. So should we word it in a broader manner so that whenever there is any conflict of interest, the member would be required to declare? Yes? I think in the principal legislation, there is mention of it. Chairman, I think it's a very difficult issue. They will have to go back and seriously look into it, because if you want to broaden it to any conflict of interest, then that might be too broad. But then if you don't, then I would ask you why. Why not? Can you go back and think about it? Chairman, the original intention is, as you have seen, in English is about pecuniary interest. So mainly we are concerned about pecuniary interest. In fact, we have also made reference to the MPF ordinance. So it's a more recent piece of legislation, and it's also drafted in a similar manner. But then Mr. Sin is asking if that should be extended to all forms of interest, including non-pecuniary interest. We will have to go back and think about it to see if it's feasible. Mr. Sin, I also have a doubt here. You said that, you should broaden it to conflict of interest. It might be a problem if it's too broad. It's like the housing authority. So if you live in public rental housing, then you cannot be a member of the HA because there is a conflict of interest, you think. But then for the monetary authority, whoever is in the financial sector should not become a member of the monetary authority, because they would also have a conflict of interest. And then for the MPF, in the board of the MPF authority, for the non-executive director, so long as I'm making contribution to the MPF accounts for myself or for my employees, then that would already constitute a conflict of interest. So that would be rather problematic. So nothing can be done about anything. Chairman will go back and take a look. So think about it. I do have some doubts or skepticism about this. How should it be worded? What about other regulators and other regulatory regime? How do they word such provisions? So please take a look and give us a reply in writing next time. Please move on. Subsection Clause 6 is about meetings and meetings of the authority must be held as often as necessary for performing its functions and may be convened by the chairperson, deputy chairperson, chief executive officer, or any two other members of the authority. And if the chairperson is absent, then the deputy chairperson will chair it. And if both are absent, then the members can elect or select amongst themselves one person to convene the meeting. And for the quorum of the meeting, it should be no less than 1/3 of the number of the executive directors and not less than 1/3 of the number of non-executive directors of the authority. In other words, on both sides, they will have to have no less than 1/3 present. Yes. And then subsection 5, it provides that a member of the authority who participates in a meeting of the authority by telephone, video conferencing, or other electronic means is to be regarded as being present at the meeting, and that members will each have one vote when there is a need to cast a vote. And each question for decision at a meeting of the authority must be determined by a majority of the votes of its members present. And if the voting is equally divided, then the chairman of the meeting has, subject to subsection 9, a casting vote. So by that, it means that he will have to consult the FS.
340版啦。
Moving on to page 340, the insurance authority can make a written resolution, and it says that they need a third of the persons to make a resolution in writing. And in clause 8, a seal and regulation of the administration. The authority must have a seal, the affixing of which must be authenticated. Moving on to page 341, we have the Schedule 1C. We had made an introduction before. The insurance authority needs to appoint a chairperson authority, and we have some questions by the legal advisor. Thank you, Chairman. On the 5th of May, a letter, it was mentioned that on page 334, in the marked up copy, page 334, bracket 6 bracket B and C, there was the use of, in bracket 6 B and C, where there was a long dash, and the question was, what was the impact of having this long dash? Because there are a lot of sections that use this long dash. Could the government, we call it the long dash. What is the usage and the meaning? Thank you, Chairman. Thank you, legal advisor. Previously, we had mentioned this with the legal advisor. We believe that this is just a matter of format. In the past, we would use a bracket to list the conditions, but in the new drafting guidelines, we use the M dash to list the conditions. We believe that visually this highlights the conditions, and it highlights the conditions. It's just a difference in format. It will not have an impact on the legal effect. Chairman, you can see that the clauses mentioned there is a condition mentioned in 4A, and then it says that the chief executive can make an appointment. In the past, we would use a bracket to list the conditions, but we feel that visually using this long dash can highlight the relationship between the two parts. Okay, let's continue then. We were at page 341, Schedule 1C. It describes the composition of the Industry Advisory Committee, and it says that they have to be the following members: the chairperson of the authority, the CEO of the authority, and not more than 2 other executive directors of the authority who must be appointed by the authority, and not less than 8 but not more than 12 other members who must be appointed by the financial secretary after consultation with the authority. The FS, when making these appointments, they have to be satisfied that in the opinion of the authority, the person has knowledge of or experience in the insurance industry and the conduct of regulated activities and consumer affairs. An industry advisory committee must meet at least once every 3 months, and a meeting of the industry may be convened by the chairperson of the authority, the CEO of the authority, or any 3 other members of the industry. And the quorum is half of the number of members. On page 342, we have bracket C, bracket D. We have conditions A, B, C, D. I would like to ask the drafting format. After bracket C, I see there is some difference in the compared to the past. We lack the word "and." Is the word "and" unnecessary, and do we still achieve the same effect without the word "and"? So you're saying that after condition C, the word "and" should be included. Thank you, Chairman. The legal advisor. She had raised this question before. We are considering including the word "and" to highlight there are conditions A, B, C, D. Okay. Mr. Chen Gimbo, I want to repeat the composition of the authority are between 8 to 12 members. Now, we had said that the majority should be familiar with the insurance industry. The advisory committee will have different professionals. We have life insurance, non-life insurance, intermediaries. So they won't be all lawyers or consumers. They will be industry professionals. I just want to repeat that. Chairman, the following clause in subclause 2, it says that the financial secretary, in appointing these people, have to be satisfied that the person has knowledge of or experience in the insurance industry and conduct of regulated activities and consumer affairs. That includes professionals. Well, I want them to be mainstream professionals. Yes, we'll take note of your opinion. When you were undergoing discussions, the government, did they promise? Well, the board of directors will not have less than 2 professionals. They said they would not ask for more. But the advisory committee is different. They are focusing on the industry. They had not resisted. That was my understanding. Yes, that is my understanding as well, but they did not say mainstream. Well, Chairman, it's called the Industry Advisory Committee. So the name indicates that it will include industry professionals. And of course, we need people familiar with consumer affairs. But the committee name indicates that it has industry professionals. Let's continue. Page 343, Schedule 1D. Previously, in Section 4F, it required that the authority functions could be transferred, and in Schedule 1D we have listed functions that could not be transferred, that could not be delegated. For example, under A, bracket A, they cannot delegate to subsidiary legislation under the ordinance or any other ordinance. They cannot borrow money under Section 4B2. And in page 344, they cannot set up subsidiary companies. They cannot appoint a person as a chairman. In bracket I, they cannot delegate the powers under sections 64 ZZF to the monetary authority under section 4G. They cannot submit to the financial secretary corporate plans and so on. They cannot delegate. The authority has to handle that themselves. Next, we deal with Schedule 2 to Schedule 8. So these are scheduled under the insurance ordinance. We are just amending the wording. The legislation does not change. Schedule 2 deals with directors and controllers, the information that they need to provide. If there's no problem, these are just wording amendments. We can proceed to page 350. The third schedule on submitting accounts and statements. We have just made some wording amendments as well. Moving forward, we move to page 397, Schedule 4. Schedule 4 says when they appoint a controller, they have to submit some information, and similarly, these are just amendments to wordings. Then we move on to page 398, Schedule 5. If they are appointed and they have more than 15% voting rights, they need to provide information to the Information Authority. It's just some wording amendment. We move on to page 401, Schedule 6. If there is a contravention of a person who has become controller, they have to submit information. Again, it's just an amendment to wording. Then we move to page 404, Schedule 7, the powers of manager. We also have some amendment to wording. Then we move on to page 405, Schedule 8, some technical amendments. Assets which qualify as assets in Hong Kong. Then we move on to page 406, Schedule 9. In the Insurance Appeal Tribunal, we mentioned that in Schedule 9 and 10, so we can jump page 425, Schedule 11. Hang on, we have some questions. Thank you, Chairman. On the 5th of May, a letter was issued. Page 2 referred to Schedule 10, Clause 5.8. Page 420 in the marked up copy. In Schedule 8, we have bracket A, B. In bracket A, B, we have 1, 2, 3. In subsection 3, we have a Chinese letter cup, the Chinese word cup. But if you look at the wording in bracket 8, there is a question in the letter saying whether the Chinese and should be changed to or. Yes, we hear that, and We read the legal advisor's letter. We agree that it should be changed to or. So you'll make the amendment. Okay, no questions. Another point regarding Schedule 10. In the letter issued on 5th of May, we have Clause 7.1, page 422 in the marked up copy. In Clause 7.1, the wording there, if you look at 7.1, it says, whether or not the requirements otherwise applicable to the making of the order. Well, in the letter, there's a question. I'd like to ask the government, why do you say that whether or not the requirements otherwise applicable to the making of the order, they can apply Clause 7.1?
And how come you can be exempted from making the order? So in what circumstances would you regard that there is a non-compliance with the requirement? All right, he'll give you a reply in writing. Okay, do give us a paper next time then. Okay. Now we are on Schedule 11 on page 425. Schedule 11. Well, with the new authority, it will replace the existing regulator. In the process, we need to make sure that the authorities regulating or regulated activities and also the work will continue, so that there would be continuity. That's why, upon the setting up of the IIA, all the records will have to be transferred. And therefore, Schedule 11 is about the savings and transitional arrangements. Part 2 and 3 are saving clauses to ensure that the regulatory regime can smoothly be transferred from the existing Commission to the future authority. And on page 426, Part 2, it deals with the pre-authority situation, including all legal actions, decisions, and applications and appeals that it is processing. Well, how that will be dealt with, and also it says that if immediately before the commencement date, an act was in the process of being done by or in relation to the former authority, the act may be continued by or in relation to the authority. Subsection 2 to 4 ensures that before the commencement date, the legal proceedings, the appeal rights, and also certain forms and documentation can continue to be discharged or exercised by the authority. Bracket 5 provides that if an act of performing a function by or on behalf of the former authority under the pre-amended ordinance was in force immediately before the commencement date, then it will take effect on or after that date. The act has effect as if the function was performed by the authority under this ordinance. And if immediately before the commencement date, an application, before any other deadline, so they will continue to be effective. Mr. Sin Chung Kai, these are also transitional issues. So for the SROs, they might be working on certain cases. So before the commencement, they are already being processed, and some are halfway through. So how would that be dealt with? So for those cases which are halfway through the processing, then that will continue. Those will continue to be dealt with, right? Yes, it's a complicated matter. So we're talking about the transitional arrangements, and we're looking at the regulator, i.e. the Commission of the Insurance Commission, the Office of the Commission of Insurance will transfer all the records to the new authority, and after this we will deal with the three regulators, and for the unfinished work that will be passed on to the new authority. Okay, so we'll discuss that in due course. 428 Part 3, that's to ensure that the authority will be able to discharge its duties without any gap. So we have to ensure that the existing records from the former authority can be transferred to the new authority, and subsection 3 provides that there is a legal basis for this transfer, and 3.1 provides that all records in the former authority's custody and are, in the opinion of the authority, required for it to perform its functions under this ordinance, then they must be transferred from the former authority to the authority on the commencement date or as soon as practicable after that date. And subsection 3 provides that the authority must ensure that there are in place proper procedures and systems to safeguard against unauthorized access to or unauthorized use of the records transfer under this section. And subsection 4, in relation to personal data transfer under this section, the Personal Data Privacy Ordinance applies as if the data had been received by the authority. And subsection 5 says that in relation to personal data transfer under this section, the authority must ensure that the data is used, disclosed, and retained for the purpose for which the data was to be used at the time of the collection. And subsection 6 says that the transfer in itself would not constitute a confidentiality responsibility, or it would not be treated as a breach of the Personal Data Privacy Ordinance. Yes, legal advisor. Chairman. Schedule 11.3. Well, in the letter dated 5th of May, there were two questions. First, it's about section 3.1 of Schedule 11. That's on page 2428 of the marked up copy. And one of the questions is that the Chinese rendition of section 3.1 can be streamlined, because at present under bracket 1 it provides that any record that has been kept by the former authority, then on the commission date or as soon as practicable after that date, the records must be transferred. But then under cap 616 is about the Communications Authority Ordinance, section 22.1. There is a similar provision. So my question is, would it be better to simplify the wording so that the former authority on the commencement date or as soon as practicable after that date transfer all the records to the authority that can replace the existing wording in Chinese, so that they do not have to have the words 准法语期移告. So that's the question in relation to this. And another one is about section 3.6 of Schedule 1. Subsection 6 says that on and after the date on which the transfer is completed, blah blah blah. And in the letter, as we have stated, we'd like the administration to supplement. So which date would be treated as when the transfer is completed? Because at present in the bill there is no specific mentioning as to when the transfer would be deemed to have completed. Would you like to answer the question, or would the Commissioner be answering? Yes, thank you, Chairman. I'll attempt to answer the first part of the question. That's about 3.1, the Chinese version. I'm grateful to the legal advisor for making reference to other pieces of legislation. But what I'd like to point out is, if you look at the English version, that all the authorities must transfer all the records. There are two parts. One, on the commencement date. Two, as soon as practicable after that date. And therefore, if you look at it, there are two parts. One is that the records will have to be transferred on the commencement date, and the second part is that if they are not able to do so on the commencement date, then after that date, as soon as practicable, they will have to transfer. So, as soon as practicable after that date refers to the second part of it. That is, for the first part on the commencement date, actually there is no need to mention that they would have to do so as soon as practicable, because if the records can be transferred on that date, then there is no need for them to state that it's done as soon as practicable. So we are talking about two types. So the former authority should transfer the records on the commencement date, and if she is not able to do that, then she should try to transfer as soon as practicable after that date. So the legal advisor has already made reference to some existing legislation, but then I think the way it is worded in other pieces of legislation, so as soon as practicable would be qualifying both the commencement date and also what's done after the commencement date. In fact, on the commencement date, if it's transferred already, there is no need to mention as soon as practicable. That's why the way we have worded it is a bit cumbersome, but then we have already distinguished between the two. Okay. On the transfer of the records, when it will be treated as having completed. Well, under our provision, we require that after the commencement date or as soon as practicable, the former authority will have to transfer the records to the new authority. So I believe that at the time when the authority receives those information, then that would be treated as the completion of the transfer, and then the PDPO will then apply to the authority. But you haven't come up with a specific date, because it's a process where some data might not be transferred simultaneously in one go to the authority. Yes, thank you. Precisely, it involves a process. That's why when they say that, under subsection 6, you think that, on and after the date on which the transfer is completed, then the PDPO will commence. So if you want to comply with the law, you will also have to make it clear as to when you would treat the transfer as having completed. And then if they receive it at that juncture, is it that they will have to receive all the data, or is it that starting from the first transfer, it will be treated as if the transfer is completed? So you will have to make it clear here. Well, in terms of the drafting, can you improve it? Okay, we'll go back and take a look, and then we'll give you a reply in writing. Yes, I'm also concerned, because is there a time limit as to when you will have to complete the transfer, and what's meant by completing the process? Because it's about how the PDPO is to be enforced. Alright, two more members, Yu Siwing. I'm also of the view that for the transfer arrangements, you will have to be extremely careful, because as we all know, the IIA has a team of staff working, but then by the time when the authority is set up, many staff might consider leaving, unless the future IIA can guarantee that it will be hiring all the staff from the former authority. Alright, it's hard to make that guarantee, right? And if you don't, then of course some staff are bound to find jobs. So in the event that should happen after the old staff have left, then it would be pretty difficult for the new incumbents to take over. And if you just put the responsibility on the former regulator without setting a time limit, the time limit should be decided by both sides, and then only after it has been agreed, the other party will try its best to ensure that 100% of the documents and data would be passed on to the future authority. And if you do not specify that, if you do not clearly delineate the responsibilities, I'm concerned that in the transfer process there would be a lot of omissions and mistakes, because it's like the TIC to be transferred to the future authority. Alright, if you just inform them right now as to what is going to happen, some would be very concerned and they would leave. So similarly, I hope that either the authority or the administration, you have the duty to not just put it clearly down in the bill. You will also have to decide on the time duration very specifically, so that at the level of the authority, of course, he'd like to get things done as soon as possible. But then if he is not able to do so, will there be support from the government? For example, if there is a mass outflow of staff, then what are you going to do to ensure that there would not be any stoppage of work?
Commissioner, Mr. Yu's opinion involves a few different ideas. There is a process of transferring information. Just now, my colleague said we would respond in writing regarding the whole transfer process, how it could be described more clearly. Regarding staff who will leave and will it affect confidentiality? Well, our legislation, Clause 53A, has a confidentiality clause, and it is applicable to all our employees and all ex-employees. It is applicable. So the law has some say over this. The next other question is, because of this transition, will staff leave early and affect our work? That is not directly related to this legislation. We have been keeping a close eye on the matter, and we have been examining staff levels, and I personally have been keeping an eye on it. When necessary, we will liaise with the government to see how we can handle a manpower shortfall. So we're keeping a close eye on it. But we hope that, of course, we can continue our work up till the effective date when the new authority will take over and all the work can be transitioned to the new authority. So how long will the interim transition take, and will it lead to problems? Well, I think we need to keep a close eye on it, and of course our basic principle is that it should not affect our regulatory work. Mr. Yu? Well, these are all conducted on a negotiation basis, but such a large change from the former authority to the new authority, there should be some legal safeguards. You're just saying that there should be negotiations, communication to safeguard confidentiality and so on. But I'm not sure whether the relevant departments, the insurance authority, can we have some binding agreement? So aside from the law, do we have other specific agreements or documents to ensure that there won't be data leaks, some other omissions? Well, the current authority is headed by myself and my staff. We are working very hard to comply with confidentiality and privacy requirements. We will comply to the T, and it's not just negotiation. When I said negotiation, I was referring to manpower shortfall. All of our employees are subject to confidentiality requirements. Even if we have ex-employees, they are also subject to confidentiality. So if they breach these requirements, it's an offense. And we already have very clear legislation on this issue. Ms. Sid Ho, in 3(1), the Chinese wording isn't that smooth, but compared to other Chinese drafting that is incomprehensible, this is acceptable. But our legal advisor and DOJ's colleagues, could we work on drafting that we can all agree on, that is the Chinese drafting? Well, the former authority and the authority, how long will they coexist? Because just now the DOJ and government officials said it's a process. So when there is such a process, will there be a time frame where they coexist in parallel? So senior management, they will have to hand over the information, and how will that affect the staff? Well, Chairman, while we are scrutinizing the legislation, we compare the new authority with the old authority, but then there is an issue of staff recruitment. There's an issue of handling existing civil servants. Will contract staff not have their contracts renewed? We didn't touch on this. So could the officials tell us, how will you handle the staffing problems between the two? Well, I think civil servants won't want to transfer to a statutory body, but in the existing institution, do we have contract civil servant staff? Do they have any priority? I don't mean contract staff. Chairman, I could elaborate a little bit. First of all, the former authority and authority will not coexist because the power and authority can only reside with one person. So there has to be a handover. But since there is a statutory regulation of the authority, we cannot have one day without an insurance authority. So there will be no gaps, and there won't be a coexistence of two authorities. So if we set a date where the new authority will establish and operate, so from that day on it will start. So the authority won't coexist. What about information? Well, we were talking about a process just now. The transfer of documents, will it be moved from our office or warehouse to the new authority office? So that is the transfer process. It can be done in one day. So will we have a gap of 1 hour or 30 minutes where who should be responsible? Well, we can look into this, how we should legislate or handle that. Regarding staff, our staff arrangement, if they are civil servants, they will retire from the civil service. Regarding contract staff, since they are contract-based, their contracts will be renewed every year or two, so we will negotiate with them. An early termination of contract, but if they say they want to leave earlier, and they might want to take a break or apply to the new authority, that will be their personal decision. If they apply and are recruited by the new authority, then their joining date can be earlier, but when they actually exercise powers of the new authority, it would be after the establishment date of the authority. They might do some preparatory work before that. It's their personal decision. Some people do not need to leave early. They might retire. They can also dovetail with the end date of the former authority. If they had applied to the new authority, then they can join the new authority on the day it is established. So, on this issue, after we conclude the scrutiny of this bill, our contract staff we will negotiate with our contract staff, and civil servants will retire on the last day of the former authority. Well, if they have not reached retirement age, then what? They are given early retirement. But what if they are very young and they had just joined the civil service? Well, the CSB will handle that. So you should have some arrangements to help them transfer and so on. Well, Chairman, 3(1) is watertight. We have a date, and after that date, they have to transfer as soon as practicable. It is a process. Ms. Ho, 3(1), it refers to records, not personnel. I had two questions, Sharon. We are now scrutinizing, well, if it touches on such a wide range of issues, then aside from this document, you need finance, personnel, office space. We cannot scrutinize in such great detail. Chairman, I can give you a quick response. The document submitted to LegCo C/250C in Annex E, we have an assessment on impact on civil servants. So we have some retirement arrangements. So put simply, we have arrangements for resignation, and staff are already aware of that. Well, my understanding is that the former authority and authority, there will be a seamless transition. They won't coexist. But before the new authority is established, the preparation will take time. And during the process, they will have close contact with the former authority. They will have to handle everything. But our scrutiny now, we need to ensure that how the records can be transferred smoothly from the former authority to the authority, and the legal basis for that. So we are now scrutinizing Part 3, and it deals with transfer of records. Well, I've concluded my question on personnel, and I'm satisfied. So that's why I said I want to return back to 3(1). I had not touched on transfer of records, and you interrupted. My question is about transfer of records. Ms. Choi said we have hard copies that can be transferred in a few hours. But what about the computer system? Why am I concerned? It's because in bracket 6, it involves the Privacy Commissioner, and there should not be a gap in the transition. So some of your records are transferred and they are given to the new authority. If it's hardware, hard copies, you can transfer that in a few hours. But what about the computer system? Ms. Ho, we need to vacate the premises at 10:30. Now, time is almost up. Chairman, if you allow me to conclude this question, Ms. Choi can answer on the next occasion. I want to ask that the computer electronic records, have you arranged for transfer of the computer system? And in the process, do we have any legal procedures that need to be handled? You have to answer on the next occasion. I don't have time to entertain that question. We now move on to the next agenda item, the next meeting, 11th of May 2015, Monday, 10:45. The next meeting will be 18th of May, also a Monday, 10:45 a.m. Mr. Sin, just now you raised your hand. You can raise your question on the next occasion. Thank you. We adjourn here. Thank you.